The meeting of the Ventura County Campaign Finance Ethics Commission will come to order. We have just barely a quorum. We're expecting one more commissioner to show up. The roll call, I guess, is we can note the presence of Ms. Tolmack, Ms. Renier, let's say Pennington, and myself. On the agenda review, consider and approve majority vote minor revisions. Those were done by the Board of Supervisors, right?
Yes, this is a procedure that is similar to what the Board of Supervisors has on their agenda. You actually have two items under the agenda review. One is correction to the minutes that were submitted originally. We had a minor correction on page 1 needing to remove the name of Margaret Peterson, our former commissioner. That's been done. And then on page 3, there was a change under paragraph 2 to better clarify what the Commission's question to the Board is concerning the issue of solicitation of funds. That was from last meeting. So
that's
those are
in item 9, right?
No, this is a revision to your minutes, and these were handed out by the clerk. So you should have that. And then, again, there's also an addendum to the agenda, and that is item 9, shown as item 9B, and it's a statement of clarification submitted by the Board of Supervisors. And we can discuss that when we get to that item.
Does that require action on our part?
An action for you to include those items in your agenda for today.
Any objection or any comments? Yes, Mr. Williams?
I received the revised. I signed up for 4, and I should have signed up for 3 because it's not plain, and I didn't receive those revisions.
I don't know if you did or not. If not, we will certainly make them available.
There are copies of the revisions on the table outside next to the agenda.
You want to go and see if they're there, Mr. Williams, and come back. Huh? Yeah.
Carol Dean, Carol Dean, the revision is a single sheet that should be next to the agenda packets. Yeah.
This is a revision packet, and it don't have her name crossed out, so it's still incorrect.
This is from the revision, Margaret.
But it wasn't in the
That's
revised.
right, because that is not the revised packet, that's the regular packet.
I thought you told me it was outside.
No, this is it.
Well, okay, I'm just trying to get it straight.
You can make an motion, Judge.
Okay.
So can I sign up for 3 then?
You've signed up for item 4.
Yes, I signed up for item 4.
Any objection to signing up for item 3? If none, why don't you fill out a form, though?
Okay.
Okay.
He's filling out it for you.
Where'd he go?
He's filling out his form for you.
Oh. Which way to go, George?
You can fill it out when you're done, Shirley.
Okay.
Shirley, you can fill it out when you're done.
Oh,
That's
okay.
fine.
All right. Can we come up now?
Yes.
Yeah, we're on item 3.
Well, thank you, Your Honor. I intended to do that under 4 because I didn't understand item 3. And just a request for point of order. My time is very valuable, and I don't think I should be charged time to make corrections because I was going to point out on the minutes that I received, Margaret Peterson was here or said she was here, but she wasn't, and I just now received that. The other thing I'd like to point out is that it says others present, and Supervisor Parks was present last week. I believe her presence is significant. Supervisor Foy is present this week. I believe his presence is significant. And my understanding is these minutes are evidence in a court of law. So I would like those considerations on future minutes or corrections to this minute here.
All right.
Just for clarification,
Supervisor
Your Honor.
Parks was here for part of the meeting last time, not all of it.
what it means as far as others present, it's actually the staff, usually to the commission, is only listed under there. What we do is we actually list the person that speaks to an item under the referenced item in the agenda minutes, and that is exactly how we do that issue. So the other presence is only strictly to the staff, which means county council staff, Dell, my clerk staff, that's who's the other present is. So it's not members of the audience. We do not put them there.
Okay. All right, on item 3, any other comments or suggestions or motions?
No, I'd move to approve.
All of the changes?
All of the changes.
Okay. Second?
Second.
All in favor? Aye. Opposed? Passed. Item 4, approval of the meeting minutes of April 20th. Mr. Williams, you wanted to be heard on that?
Well, I consider that
The same thing?
same thing.
Okay. Item 4, any comments or suggestions or motions to approve the minutes, I hope?
Yeah, based on the prior motion, move to approve.
Second.
Okay, moved and seconded to approve the minutes of April 20th. All in favor, say aye. Aye. Opposed? Passed. Number 5, public comments. Are there any? Oh, I thought you were only on 3 and 4. I didn't know you were on 5. We got more cards than... Okay, well, if I don't know it, I'm going to pass you by. Okay. No, we're not going to chastise the clerk. And for whatever it's worth, Mr. Williams, whatever your comments are.
Can I have a ruling on my point of order where I've had to speak to the corrected minutes, which I don't believe should be charged against me, and I was denied the revised, and it still isn't in the revised agenda outside.
The limit is still 5 minutes, but I'm sure you can make it. Okay?
Yeah, you know you have the authority.
I know I do.
Well, I just want that on the record.
Okay.
I will speak to the minutes, but not to the revision of them. I mentioned in the minutes several times, and I believe it's very egregious of this board not to put that Harold Dean Williams states that he's here under the Brown Act to criticize you and to exercise his First Amendment. That should be in the minutes. That's why I'm here. And you treat me differently than you treat other people.
We try not to, Mr.
Well,
Williams.
and then when
Sometimes it's
Roberta
hard.
won't give you my card and pass me up, she does need to be chastised.
That's
Now,
not-
I'm a member of the public.
Mr.
and
Williams, stop it. Please calm your voice down, all right? Please.
The Brown Act gives me the right to be here, and that's the law that I go by.
All right. I'm not sure I understand that, but it's all right. The Brown Act says that everything we do, we have to do in public, which we try to follow.
a revised agenda for the minutes. I was denied that.
All right. On item 5, any other public comments? If there are none, we'll move on. Number 6, commission member comments. If, do you have one? If none, we'll move on from 6 to 7. The consent agenda item, review and approve consent matters. Aha, we have a fourth commissioner. The record will reflect that Ms. Jones is here. We're on item 7 at this point. On the consent items, do we need a motion?
What that would be, Your Honor, is you actually would be approving item number 8. So you can take item number 8 and 7 together.
Oh, okay.
Ah,
That's my
okay.
confusion.
I don't think there's any controversy on that, is there?
No, unless you have any questions about item 8, that's really just a notification to the commission to let you know that Commissioner Renier's term will expire July 1, but she is eligible for reappointment to a full term. And one of the amendments recently approved by the board on Tuesday and effective June 8th would allow the board to reappoint her without using the independent selector process.
That wouldn't be today, though, would it?
No, no.
Okay. All right.
Well, is it necessary for me to address this at this time?
Only if you choose to. It's a receive and file, so.
Well, all right, I'd move to receive and file, but I'm not prepared to address this at this time.
I'll second.
Okay, I don't think we need a motion, actually, just we will receive and file it as such. All right, item 9, receive and file an oral report on amendments to the campaign finance reform ordinance.
Yes, Chair Peck and members of the commission, at your last meeting in April, we provided to you information about a number of changes to the campaign finance reform ordinance that were being considered by the Board of Supervisors. They approved and adopted those on Tuesday, May 8th of this week. And that's shown as attachment A, and that's item A, 9A. What we also provided to you with this item is the addendum to the agenda, which is item 9B. And that's a statement that the Board of Supervisors adopted to provide clarification for the Commission on Section 1269C of the ordinance as it pertains to the receipt of excess contributions and then the return of those contributions within 5 business days. And you'll see from the language that was provided by the Board of Supervisors that they are indicating to the Commission that it was their intent that that section would not constitute a violation of the ordinance. And that information is presented to you for your information. And also, it will have some bearing perhaps on the hearing that you're having today, that complaint.
There's no motion, or at this point it would simply be filed at this point?
Correct. This is for your information.
And this is item 9A, right?
9B. It was
9B.
the addendum. Mhm.
The reason I asked is Mr. Williams has got a request to speak on 9B. I gather if we are on it at this point,
Yes.
I'll ask Mr. Williams.
Thank you. How much time do I have left?
4:18.
Thank you.
We ran you back up to 5 minutes, okay?
Well, thank you, Your Honor.
You're welcome.
Thank you. Thank you. I appreciate that. It's not that my criticism of you is personal. The law gives me that, and Steve Bennett criticized you Tuesday in my presence at the board meeting, and your kindness has took a little bit of my thunder away. But the point is, the way Steve Bennett, one of the authors of this ordinance, is saying that this commission is not doing its job. It's not understanding the plain language of the ordinance. And to quote him, what this commission has done and hired these investigators at huge expense, this interpretation is illogical, as it results in Section 1269C having no meaning at all. Well, this section is still ridiculous because it should be 5 days after county elections discovers it. Here's the treasurer of the committee trying to be focused in on 5 days of finding it. It should be within 5 days when election finds it. Because it's the same scenario that created this, that the other 5 days that will not be addressed in the board's letter to you. So, thank you.
Okay. I do think that last point, if I understand it, probably is better taken up with the Board of Supervisors, who in fact can amend it if they want to. We don't.
Okay. Do you agree with Mr. Bennett that your decision was illogical and do you agree with Mr. Bennett on that point?
I don't know whether I do or not.
Okay.
We try not to do anything that is illogical. We leave that up to others.
Okay. Thank you.
Okay. All right. Items 9A and B we've gone through, I think. Item 10 is hold a discussion, provide direction regarding on the penalty and fine policy. Is that we're back to 9B again?
No, this is agenda item 10.
Yeah.
Can I just have you receive and file the information provided on item 9, please?
Oh, I see. Of course. I thought we just did.
I didn't hear a motion.
Oh, we need a motion to file?
Yes, you do.
Okay. Moved and seconded.
Thank you.
Any comment? All in favor? Aye. Opposed? It's done.
Thank you.
Okay. That is item 10? Okay, well, then item 10 is discuss and provide direction. What is that?
Chair Peck and Commission members, I've put this on the agenda because at your last meeting there was some discussion amongst the various commissioners about the lack of guidance as it pertained to the determination of fines based on whatever severity of violation you might find on a violation. And what we thought might be helpful to you, since we don't really have much in the way of experience or history with this commission on the assessment of fines and penalties, is perhaps to have staff bring back to you some information about what other established ethics commissions have adopted in the way of waivers, administrative fines, penalty policies, and so forth as information. And then if you chose to develop your own type of policies in that regard, perhaps those could be used as a basis for that. But it's strictly up to you if you feel that that would be something that would be helpful to the commission.
Well, personally, I'm not sure, because how other commissions work is not necessarily, well, it isn't binding on us. What we try to do is to follow the ordinance as it's given to us, and if it requires interpretation, as it's interpreted to us. So personally, I'm not sure whether it would make a whole lot of difference. It's basically what the ordinance in this county says, and not what it might be in L.A. or Kern or some other place, but maybe somebody else feels differently.
What it says or doesn't say,
Yeah.
which is what we ran into last time. So.
Yeah. Does anybody have other opinions? That's just mine.
Well, I think there was a brief discussion last time regarding what other commissions are doing. We had an opportunity to hear that. But I tend to agree with you that we are in a position to review the ordinance and act on it, and if we need to get further clarification, we will do so.
Ms. Tolman?
Just as we did with this past one.
Well, basically, I think what we have before us is an offer to go ahead and do that. The question is whether or not we want to ask you to do it or not.
Right.
It's just a matter of whether you feel that kind of information would be helpful. And again, it was really more from the discussions you had at your last meeting. It appeared that perhaps that might be helpful information, but if you don't feel you need it, I have plenty of other things I can do.
Okay. Personally, I don't. Is there anybody who disagrees? Currently not.
Great.
So if, however, in the future we decide it might, then we can ask at that time.
Perfect.
Okay. So we want to hold this discussion at this time? And whether, and it does, I mean, it's the next item on the agenda, or not the next item, but the hearing on the agenda is going to be really affected by that.
Well, possibly. I guess what I was thinking that you might want to see is there are some ethics commissions who have adopted policies that are related to less onerous violations of the ordinance, I guess is one way to put it, where depending on what the level of the violation is based on what the commission thinks, the penalties are less severe. And they've adopted those as policies. So, for example, some commissions have infractions policies where they've decided that if you're late with your report, that's just an infraction. It's not a full-on severe penalty. And that was just, again, an offer. And it appears that the commission really doesn't feel it's warranted at this time. You know, as we get into more of these cases, maybe it will become more of interest to you.
Yeah, personally, I'm looking for direction from this board, not some other board, and until it gets up, until it becomes a constitutional question of cruel and unusual punishment, which I don't think we're going to get to. Then it just seems to me we should follow the direction of the board. What we have here is sort of a quasi-direction. They haven't amended the ordinance. They've just said this is what we meant.
That's fine.
Which is a dilemma.
Mr. Chair, may I
Sure.
add to this conversation? I think that maybe to focus on the intent of what this agenda item was, the ordinance as it now stands provides a range of penalties
Yes.
that your commission may impose in any given matter that's brought before you. At the last meeting of the Ethics Commission, there was a recommendation with a stipulation and for a particular penalty or lack thereof, actually. And there was some discussion at that time that, well, the commission didn't really have any guidance to go with, and you didn't particularly agree with what was being recommended, so you voted against it. At this point, I think what staff was looking to do was to assist your commission in developing your own guidelines by providing you information from other jurisdictions and what they're doing as sort of the first step of the process, where your commission could then start to develop your own guidelines and whatever for cases that will come before you, to give, so that in every case you're not just kind of going back to the drawing board, and I guess to give some sense of like cases being treated more in a like manner. And that's really what was being suggested to you, I think. So if your commission wants staff to start that process, then you can direct staff to do that. If you want to leave it as it is now, which is you'll hear a case and determine on the basis of that case what the appropriate penalty or remedy is, then staff can do nothing. It's just really for you to give direction on what you want.
Isn't it the Board of Supervisors, though, that drafts these, or is it our commission?
No, the board has provided a range of penalties. It is now up to your commission in any given case to determine what is the appropriate penalty within that range. For example, there's a penalty where it says you can up to 3 times the amount of a unlawful contribution, but it doesn't have to be 3 times. It can be less. So I guess the suggestion is that you want to have some guidelines for where it's appropriate to impose one-time penalty, which was, for example, was on the other matter that was heard at the last meeting, there was a recommendation for a penalty of 1 times the unlawful contribution or expenditure, and that was approved. So, that was within the range of what the board has authorized in the ordinance. So it's just a matter of whether you want to have some guidelines for your own commission in dealing with cases as they come up, or if you just want to determine it on a case-by-case basis.
How does the board feel?
Well, at this juncture, we are going to have to deal with this on a case-by-case basis since the situation faces us today. My concern, and I think this was raised last week, or at the last meeting, is setting precedent. However, if there's a degree of flexibility that we have, and I would like to again review the specific provisions. It was my understanding when I reviewed those provisions that it said 3 times the amount or $5,000, whichever was greater.
But we don't have to do it. That's just we can do up to that point.
But we don't have to do that. So,
That's right.
In other words, we can find something larger than that or no fine at all based upon the guideline, the ordinance as it stands right now, is my understanding.
In a sense, that's what I believe the hearing that we have scheduled on item 12 is about. But what the board has sent to us is that there was the consensus of what they meant was that if any overages in violation of the ordinance was returned within 5 days, it would be a no harm, no foul.
That's not what the ordinance said.
Well, that's a whole different argument. That's
I didn't hear Supervisor Bennett's criticism that Mr. Dickey just referred to, Mr. Williams, but we can only do what the ordinance says to do. And if it gives us the authority to set a penalty, then I guess I'm missing the issue.
well, what we're, I think, if I'm correct, Mr. Hardy, is that whether we give direction to staff or not, and if we do, in what direction. Am I correct?
On this agenda item, yes, the issue is just whether you want to direct staff to take the first step in the process of bringing information to your commission to assist you in developing your own guidelines for penalties that can be assessed by the commission, or if you just want to defer that to a later date, or you're not interested at all, you would just not give staff any direction at this point.
Whatever penalties we decide to assess, if any, at the very least they ought to be uniform, which also goes to this issue, I think.
Yes, I would agree. That would be the idea behind it.
Which means we need guidelines.
May I solicit further decision? Do you want to just pass it over, or do you want to give them guidelines, and if so, what?
I think I'd like the board to make up its mind what what it would like us to do. There's an ordinance, and
Well, the board has simply said that it was their feeling that certain infractions, if I may use that term, were so de minimis that they should get no fine. Those were if contributions were returned within 5 days. But this is bigger than that. This is actually, do we want to set up further guidelines so if nothing else we have uniformity?
I personally feel that further guidelines would be helpful so that we're not establishing precedent that we will have to ultimately change in the future.
Yeah. Ms. Tomac, you have any feelings?
Yeah, it might be helpful to have the information from other agencies, but certainly, as with this situation, the board has had it is giving us their interpretation of what their action was in setting it up as it is, and setting up the requirements. They did, it was up to, and I thought that the having that as a top limit certainly was one interpretation, but then the specific reasons for the 5-day was entirely different, and I think that I would think that if we spend more time on interpreting the ordinance, it seems to me that we will be developing maybe new questions that we might want more information about, but or we might develop our own pattern of
Are you willing to go along with the proposal I think Ms. Renier was making, that is, ask the staff to bring back a further report?
Yeah, I would think that would be useful.
I'm not opposed to it. I'm a little concerned about the board drafting an ordinance and then coming back and telling us we didn't get it right. And, you know, at some point there should be a
That's
line
on
of demarcation between what we do and what they have done. But if we need more guidance, then...
Well, there are two issues here. One is the narrow one you're talking to.
Well, I
but
guess
the
that's
other,
the narrow one.
Huh?
I'm still a little rankled about hearing we were criticized.
Well, you know, one thing you learn is there's a reason for the hearsay rule. All right, and what it's not always valid. So I'll wait until I hear further on that. And besides, yeah. So you want to? I want to get out of the way first. The second item, you know, do we give direction to staff to come back with some suggestions and recommendations, and then we can take up the other item of the what I refer to as no harm, no foul, but basically within 5 days that we don't assess a penalty. That was the intent of the board.
Is it
Which I think could pass by 3-1 if I'm correct, but I'm not.
Is it your desire to have guidelines, further guidelines?
I think that it might be very helpful, personally, simply because it gives a uniformity which I think everyone who appears before us has a right to get. You know, it's awfully easy to forget that 3 months ago we assessed a fine of X dollars and now we're assessing a fine of Y. And if that were to occur, Mr. Williams would quite properly be before us complaining. The orange cards are coming in.
So how, then is it a consensus?
I hear, I think a consensus of at least 3 and maybe 4. Am I correct?
Yes.
Okay. Through all of this, have we given you a glimmer of what we're asking for?
I think I sense that the commission would like to have a report back, which we will do.
Yeah. Okay. Let us ask you to do that then. And then do you want to take up the narrower issue of the intent that we got from the Board of Supervisors, which rankles you?
Well, to a degree, because, we sat here at the last meeting, and what I'm thinking specifically of is you're not allowed to accept X amount, but you're allowed to solicit X amount, and that's not in there, but and that could be freedom of speech, and.
That could come in the report we just requested.
Yeah, I mean, if there's confusion.
Well, let me ask you this. Let me sidestep the issue of the fact that the board said this is what we meant. The concept of not assessing in certain instances where the wrong is rectified quickly. Does that offend you, except for the fact that it came from the board?
Except for the fact that it's not in the ordinance. That's my problem.
Well, actually, I had the ordinance copied for me. I think this is it. Yeah.
Mr. Chair, just as a point of order, it sounds like you're going back now to item 9, which has been kind of resolved already, or that there was already a motion to receive and file that.
We've received it and filed it, yeah.
And we moved on to item 10.
We can move on. I was invited to go back. So.
Yeah, that's
I'm just-
right. The fault lies with
We can
me,
go
not
on.
with Ms. Jones.
Yeah, I'm just, there could be a motion for reconsideration if you want to go back to that
No,
item.
there's no reason to go back. I'm fine.
Okay. Then we will drop that issue unless there's objection. All right. Was there another request to be heard, Madam Clerk?
Not yet. For item 11.
Oh, okay. All right. Item 11 is the request for authorization to amend the complaint, and I think this is the one on the Republican Central Committee, is it?
Judge, you need to take up the 1 o'clock administrative hearing. That is a time certain.
Oh, okay. Excuse me. Apparently, I'll have to drop it and come back to item 12 because it's set at 1 o'clock. I beg your pardon. I assume Mr. Foy has other places he'd rather be.
Okay.
Okay.
If I can speak to Supervisor Foy briefly before we proceed. This may expedite the process here.
Right behind you in the seats there. You want to speak with him?
Yeah, I think he just asked if we could take a break for like 2 minutes before we got to this item from the other agenda items, because he just wants to work
Okay.
out some procedural details with Mr. Roy about how the hearing will work.
It's fine with me.
Yeah, literally just a 2-minute break. Thank you,
Okay.
Your Honor.
Anybody need a break? Mr. Williams, what I will do is put on the record your objection.
Thank you, Your Honor.
And that is in the ordinance. That's it. C.
Oh, I've got one over here.
You ready?
Oh, yours not, yours isn't on. Okay, yours isn't on.
Okay. We're on item 12 now, the evidentiary hearing. You've had an opportunity to discuss this with Mr. Foy.
Yes, Honorable Chair and members of the Commission. Supervisor Foy and I would like to submit a joint stipulation on the facts in this case, basically based on the records that are part of the agenda packet. If I need to review the facts with you again, I will do so, but in essence, an individual
Do we need, just so that we have a written record, do we need to find those facts, not necessarily right now, but at some point, and make sure that everyone is agreed on them so that what we have, we have?
Well, Supervisor Foy and I have stipulated to those facts. We are asking you to receive those in evidence.
I'll be glad to. I just want to make sure I know what, not only me, but what you know what they are.
Yes. I mean, they are the documents as set forth in the agenda packet, which basically, consist of a filing that indicates that Joe Casella has contributed $300, and then another $300 was contributed by Simi Pacific Building Materials, and another $300 was contributed by Pacific Building Materials Incorporated. I think what we're stipulating to is that those three contributions, in essence, are from the same individual, which is Joe Casella, and therefore the contribution would, in effect, be $900.
Could I hand you what I got, or I just want to make sure we all are on the same page. I'm sorry. I've been a judge too long. For whatever it's worth, I think it's a good idea to do what we're doing, which is to stipulate those so we do have the evidence on which we are going to.
Well, Your Honor, tell you what, why don't I give this back to you, and I have this packet myself. I can just go
Okay.
through the documents as well.
Okay.
Would that be helpful?
It would be helpful. I just want them identified so everyone knows, what it is we're taking too much time on it. It's all right.
Okay, I'm looking at,
Sure.
as part of the agenda packet, I'm looking at 12-1, which is
Yes.
a copy of the complaint.
Yes.
More importantly, I'm looking at 12-1A, which is a late contribution report, Form 497.
Okay. That is in the agenda as well.
And if I may note on that, page 1, you'll notice a contribution from Joe Casella. And on the following page, you have a $300 contribution from Simi Pacific Building Materials, as well as a $300 contribution from Pacific Building Materials Incorporated. In essence, we're stipulating that Joe Casella is the owner of the two companies that also contributed $300 each. That's not in dispute. 12-2 is a probable cause determination. And 12-2A is it looks like that's a probable cause determination. 12-2 is a notice of probable cause determination. 12-3, more importantly, is an email correspondence from Virginia Bloom of the Elections Division to Ms. Jamie Tanker, who is, I believe, is a treasurer of the Peter Forster Supervisor Committee, and a response from Ms. Tanker, where she states that the money has been returned. I believe those are all the relevant documents.
And 12-4, which is,
12-4 is my brief, which doesn't need to be part of the evidence.
okay, that's not a part of it.
That would be my brief.
All right.
And I gather, if I could just make sure we have a clean record, the stipulation so far is that these certain documents exist and say certain things. Is there a joint stipulation as to the truth of all of the events described in those documents? So that the factual basis is there as well? Is that?
I believe so. Yes.
If we could get maybe the supervisor to put that on the record, that you stipulated, you agree to the stipulation? Yes. Okay. When we have that record, then.
The record will reflect that he's both orally and demonstratively, thank you.
And the only other item I would have, because it may take up some significance, is that the response email from Jamie Tanker was dated 6/5/06, June 5th, 06. So the implicit in that is the notion that the monies were returned to CME Pacific Building Materials and Pacific Building Materials either on or before June 5th, 2006. Is that correct?
Yeah,
That
with
is
that,
the implication.
and with that stipulation, we presume that's a given.
Right.
Yes.
Okay, those are the items.
I believe the crux of the case now is a little bit different than what we talked about before. I think that the crux of the issue is there a violation? And then the second issue would be, what should that violation be?
What should the violation be, or what should the penalty be?
I'm sorry, what should the penalty be? Thank you, Your Honor. My position is set forth in my brief, and as I originally argued, is that there is a violation in this case, despite the fact that the money has been returned within 5 days of notification by the Elections Division, because the section under which Supervisor Foy is relying upon to claim, I'm assuming this, to claim that there is no violation whatsoever is 1269, I believe that's C. And 1269C does not, on the face of that section anywhere, state that a return of money within 5 days, therefore, renders the money previously received as not have been received.
No. And
It doesn't say that on its face. I also note that in this particular case, there was a knowing violation in the sense that the original contributions were identified such that a very easy review of the contributions would have indicated that they're all basically from the same person. So this is not a situation where this is a blind contribution that's going to be eventually determined as from the same party.
may I ask a question?
Yes, sir.
Would these facts, as we've stipulated to them, come within the purview of the explanation from the board regarding the fact that their reading of this would call for no penalty? I don't think that that it would call for no violation, but it would call for no penalty.
Well, and Mr. Wucher may want to speak on behalf of the board. I hate to argue both sides of the case, but my understanding is that the board believes that there would be no violation in the first place.
No violation?
No violation in the first place.
Okay.
If the contribution is returned within 5 days.
Okay.
And Mr. Wucher can correct me if I'm wrong on that.
I don't want to speak to the board's intent, or I wasn't there, I wasn't representing the board in that context. But, I mean, I think we have what their statement is. But I do want to direct your attention to another issue in terms of interpretation, and that is, and again, I can't speak to the board's intent when they adopted this, but I am familiar with the structure of this ordinance in comparison to other campaign finance ordinances around the state and the cities. And I would direct your attention that Section 1269 is a separate provision than Section 1267, for example. 1267 sets forth the basic restriction of the $300 limit for a candidate or the candidate's controlled committee and how much money they can receive from any individual. It has no provision that talks about an inadvertent violation or return of the contributions. If you look at 1269, it's entitled Contributions to Candidates and Committees that Contribute to Candidates. And what it appears to me from the language it refers to is the fact that the ordinance imposes an aggregate limit on the amount of money that any individual can contribute, not just directly to a candidate's controlled committee, the Peter Foy for Supervisory Committee, for example, but also to any other committees that are themselves making expenditures, independent expenditures, to support or oppose that particular candidate. It's a way, I believe, that was intended to prevent people from circumventing the restriction that applies directly to a limit on what you can give to the candidate, him or herself, by funneling money to a number of other committees that will then make contributions to the candidate or will make expenditures. So if you read the actual language of A, it talks of 1269A says the combined total a person is allowed to contribute to a candidate's election committee and all other committees that contribute to that candidate shall be no more than $600. It then goes on to say that a willful or knowing violation of that shall be punished under 1294. That is, it's subject to the penalties. B says, of that same provision, says no committee, and again now it doesn't say no candidates control committee, it just says no committee shall knowingly accept a contribution in excess of $100 that will cause the $600 limit to be exceeded by an individual contributor. And C says if a committee discovers that it has accepted a contribution in excess of $100 that has caused the contributor's $600 limit to be exceeded, the committee shall return the contribution within 5 business days of the discovery. Now, I believe one plausible interpretation of this is that it is intended to deal with a situation where the two committees don't know that a person has contributed to the other committee. That is, a candidate receives a $600 contribution or $300 contribution, whatever the maximum contribution is. Another committee also receives that contribution and then is informed subsequently that, oh, that contribution put the contributor over the aggregate limit. Not that the single committee received more money than they were allowed to accept, but that in combination, that put them over the limit. And in that situation, upon discovering that they received a second contribution from that individual that because of a contribution made to another committee put that person over the aggregate limit, they should return it within 5 days. And I think an implicit understanding of that is that they shall, correct, right, is that if they do return it within that 5 days, that it's not a violation. So to that extent, I believe the statement that the board recently made makes sense of saying the intent is if we do, in fact, give it back within the 5 days, and it was inadvertent, which is one of the restrictions that in C itself, then that shouldn't be punishable as a violation. But if they discover it and they hold it for 5 days and they don't give it back, then it would be a penalty. But I think that is a separate situation than the facts that we have in this case, which are that the single candidate-controlled committee received contributions from one individual that exceeded the limit, which to me would appear to be covered not by 1269 at all, but directly by 1267, which is the individual limit that applies for all contributions that are aggregated from the same person to a single committee. And that's my... You know, it's your determination as to how it ought to be interpreted, but that's one reading that I think is consistent with the language.
I have a copy of 1269 B, C, and D. I don't have a copy of 1267.
That would have been, yeah, 1269, the title, and I can pass my copy along and everybody take a look at it.
Okay.
I think immediate question would be, is there any provision in 1267 comparable to 1269C?
There is none.
There's not. No.
No. I've been reminded that that copy you have is the original version of the ordinance that several years ago. It has subsequently been amended to change the $100 to $50.
$50.
Yeah, that's right. But that's the only change from the earlier, the sections, the title and subdivision A.
Okay, go over again how 1267 applies and not.
So 1267 is the typical limit that says a candidates control committee cannot receive more than X amount. In this case, $300 if you're a non-participating candidate. Ventura's ordinance is a little different because the ordinance does accumulate in section 1269. It adds a separate limit here that says not only do you have to apply by the 1267 limit, but all committees combined that make contributions to a candidate cannot receive more than $600 from a single individual. That's in subdivision A of 1269. And as I say, that's intended to prevent people from parceling out contributions, essentially funneling contributions to a number of different committees and then having those committees in turn give contributions to the candidate. So you have a $300 limit initially, maybe a $600 limit in the aggregate for multiple committees. And as I said, I think they are different. They're intended to deal with different things. 1269 has this 5-day grace period because it's not necessarily reasonable for one committee to know if a candidate gave money to another committee. But if it's a single committee, they know who's been given.
These contributions all came from a single committee.
They all came to a single committee and ultimately from a single source. That's the stipulation of the facts. Yeah.
Okay. Everyone understand?
I understand, yeah.
Okay.
And to clarify a discussion that occurred earlier, I don't think the board's criticism, such as it was in that statement of intent, was at all directed towards your action in the last meeting dealing with whether there should be a penalty for a violation or not. It was intended, I think, more directly to address Mr. Hardy's interpretation of 1269, in which he took the position that he believes even if you return it, it could still be deemed a violation. They seem to be saying if you've met the facts of 1269C and you have returned an inadvertent violation, an inadvertent contribution, they don't really think their intent was to make it a violation. But it was not, I believe, directed either to the commission itself at all or addressing what occurred at the last month's meeting.
Well, even in defense of Mr. Hardy, though, I tend to agree with him. So.
We'll get to that. You want to give this back?
Excuse me.
I mean, a lot would depend on how it's discovered.
Okay, anyway. Would you have anything else?
I have nothing else, and I hope I didn't go too far, as much as I did say.
Well, I should add, Your Honor, I do make that point in my brief about there are two different schemes here. And the 5-day return scheme applies to the situation where you've got multiple committees, and this isn't that situation. I would also add a little bit differently than Mr. Wucher is that I don't see I think that legislation should be explicit on its face about a grace period. I still deem the return of something in 5 days as an additional requirement, and that there is a grace period required, or if there is a grace period, it should be explicitly stated on its face, which most, I believe, laws and ordinances do.
I would certainly agree with you, and obviously Ms. Jones agrees with you.
I certainly agree with him.
And perhaps others.
Well, I do. That issue really wasn't raised at the last hearing. We were talking in terms of fines or no fines. And I think it's very clear. There is no provision excusing a violation of...
Even if it applied.
Yeah. Of 1267.
Yeah. Okay.
Your Honor, I'm not sure how you want to deal with this. Do you want to deal with this in two phases? Because this is an evidentiary hearing, so Supervisor Foy, of course, needs to present his case.
Sure.
And I can present rebuttal if necessary.
I'm taking what you're saying now as argument.
Yes, Your Honor.
Am I all right? I gather that by the stipulation, we are past the evidentiary stage.
Yes, Your Honor.
We're into argument, and I gather your argument would go first.
Yes, Your Honor.
Which is quite proper, and then, of course, we'll hear from Mr. Foy.
Yes, Your Honor. I haven't made any comments about the level of penalty. If you want to wait on that, I still believe there should be a zero penalty. That's my position. I don't really need to add anything more. If you do find a penalty, if you do find a violation, my position is still. But
your zero penalty is based on specifically what?
it's based on a couple of factors. There's no history of violations by Supervisor Foy. The relatively small amount of the overage in this case, and the fact that Supervisor Foy cooperated with the investigation, and the fact that they did return the money within
Once
5
they were
days.
caught.
I'm sorry?
Once they were caught.
Well, I mean, I think that's a critical factor in terms of the violation itself.
Yeah, obviously, in any of these, this is being our first hearing, I think. In any of these, if we find some sort of willful, flagrant ability to go around clear ordinances, that's going to be treated more harshly and should be. I gather you don't perceive that in this.
Well, I agree with that statement.
Yeah.
I do agree with that statement. So
Yeah, but you don't perceive it in this case.
I do not perceive that in this case. I think it was a clear violation that should have been caught very easily. My understanding is that the treasurer of Supervisor Foy's committee, it was not a seasoned professional, and this is a first-time campaign. I'm not saying that's an excuse, but I'm saying in levels of maliciousness, that's meaningful to me.
I was the treasurer of a congressional campaign back in pre-Cambrian days, long ago. Drove me nuts. Okay. Then we can have, I gather, Mr. Foy at this point. Just to get one thing out of the way, Mr. Foy, just 1 minute. Mr. Williams, I said I would put your objection on the record, and I will do that, that in this hearing, Carol Dean Williams has submitted a card asking to be heard on this particular agenda item. It is the view of council and also, frankly, of this chair that while you do have a right to comment on agenda items, this is a different kind of agenda item. It is a hearing. And it is our opinion that you do not have a right to come in and comment on this, only people who have things relevant to the hearing itself. Do you want to be, your objection is based on the fact that you feel under the Ralph M. Brown Act as amended that you have a right to be heard? Just briefly, if you want.
Just briefly. Your Honor, to clarify what I was told by the clerk I could not speak on item 11, which is a regular agenda continued. That's what I was told, and I had a card for 11. She told me 11, and I have a card for 11, and I was not called for 11.
We haven't even heard 11 yet.
Well, I didn't hear you go out of orders, and she told me 11.
We did.
We did. I'm sorry, we haven't heard 11 yet. We had a hearing announced at 1. It's now 1:45.
Yeah.
And so we obviously went to the specific item.
Okay.
We haven't heard 11 yet.
All right. Well, that's what I heard her say was 11.
Okay.
And,
This is just, I just wanted to put this on the record so it will appear on the record.
thank you, Your Honor. I really appreciate that.
You're welcome.
And, Your Honor, just to clarify my position, I did hand him the card for item number 12, not 11.
Okay. Now, Mr. Foy. You never get these arguments at the board, right?
Everything's always nice and easy. And anyway, thank you, Your Honor, members of the commission. My name is Peter Foy, Supervisor, Ventura County. I want to just address a little bit of this. First of all, there were no disparaging remarks made at the board about your things. What there was a desire to interpret what Mr. Bennett and Ms. Long had written when they wrote this. I wasn't involved when they wrote this, but that's what they tried to do, was to give you some of that. Because when this had come up, they had said that's not going with what we had done. So that's what they did. They were just trying to say Section C, 1269C, it meant something, and if there would be no reason to have that in there if it didn't mean what they were saying there.
And apparently, the interpretation we're getting here today from Mr. Wolsher is that it's not applicable in any event because it's a single committee, not a double.
That's not. I take.
I'm not asking you to agree with that.
I don't agree with him on that because that's not what they said. That's what they said. This is for all this because as you look at all campaigns, federal, state campaigns, and even in this, if you take a contribution above limits, you must return the contribution that goes above the limits, and there's no penalty. As a matter of fact, in a federal or state, there's never a violation. There's no time limit. We're very restrictive in this finance that we have here now, and so this requires 5 days. And that was their intent. Just if you find out you've done it, or it's been over the contribution amount, return it, and that's what we did. And like we said, we had a young woman doing this for us, and as you said, it's not the easiest thing in the world. But that's not the issue to me. The issue to me is that the requirement is that you return this within 5 days. You do that, and you've met your legal requirements to do that, and that's what we believe. So, but going back to this whole situation, remember when these are written, it's a legislative intent is what we're looking at. And that's what I think we have to make sure that we do agree with, that legislative intent is that people can only contribute so much, and that's all they can contribute. If they do send you more money, just send the money back, and just make sure you stick with that. And I think that's what we have to do. We don't want to add anything based on personal desires or anything else to any of these situations.
No, I think the problem that at least a couple of us, and maybe more, have articulated, though, is that if you read the ordinance, that intent doesn't appear that easily. It doesn't say anything about if you get it back within 5 days, there will be no penalty.
Well, what reason then would there be to where it says if you accept the limit and $50 above has caused to contribute $600 or more, he exceeds that, just return it within 5 days. What would that mean then?
Well, all I'm trying to say is that we think that, at least some of us think, that the ordinance itself should be made clearer.
Exactly, and I think that's what they tried to do here.
Yeah.
Remember, this was voted 3-1.
I understand.
Guess who voted against it? Me.
I know.
Because I voted against because there's other things that are involved that I think are wrong. So I wasn't voting. I didn't. People say, "Well, why didn't you vote? It would have helped you." I have more principles than that. I voted against for other reasons. But these
a politician who will vote against his own interests is a thing to be wondered
at. But anyway, so I think they were trying to clarify this. Mr. Bennett had talked to me. This is an issue. So I mean, he was trying to make that clear because this issue is a big issue, and that's what he did not want to make. Because again, this is a very restrictive policy that we have in this county comparative to Fed, state, and everything else.
It's so controversial, I think.
Very controversial in that situation that you'd have a violation because you could have somebody you could give to our clerk here as if she's running, and then all of a sudden you give your business gives and the whole thing goes over the same committee, but you got to go back and do it again. Somebody looking at this, I mean, as Ms. Jones here had said, well, when you get caught. I don't think it has to do with getting caught. It's the idea if somebody wanted to do that, I'm sure they could find ways to make this thing reported on different reports, do a whole lot of different things. But if a person's just listing all the checks they receive and send them in, I don't think they're trying not to get caught. So I think it has to do with a very clear understanding that contributions are made by a person, also owned by a business. They go over the $300 or $600, whatever it was. But I truly believe that the board was very clear. And I'm sure we'll see more of these come out as things come up and the board wants to make clarifications so that they do. And again, for myself, the clarification comes out, it's a little bit harder for me because I wasn't there when they wrote it and they voted on this. Mr. Bennett and Ms. Long are the ones who did that. So anyway, that's what I wanted to say. I appreciate it.
And we are finding these things all the time, and we're trying to correct them when they come to our attention.
Right, and it goes back to the idea, once you start making a whole lot of rules and limitations on things, nobody can think through all the processes. So, well, thank you very much.
I just would like
Yes.
to, can I?
ask a question before?
Sure, of course.
Why was the clarification not specifically applied to 1967?
1267.
Yes, to 1267. That's one of my concerns because there is nothing in 1267 that addresses that issue. And because there are two, as is so carefully explained by Mr. Wouter, there are two separate.
Well, I'm not sure that Mr. Bennett and Ms. Long would agree with what he's talking about, making them separate. They just said in this situation where any contributions over a certain amount are need to be returned within 5 days. That's what they were saying on this. Otherwise, because that's what they said, this is what the whole thing came up with, was this whole situation. That's not our intent. Because even Mr. Bennett said to me, "How's that come? It's right in the rules." I said, "Well, they're applying it to me that you didn't you returned the money, but it's still a violation. It can't be a violation. We have it directly right in there." And that's why I'm sure they probably brought that back. I didn't know about it, but they brought it back and showed it.
I think you understand our position.
Well, I understand your position, but I'm just saying, you asked me why they didn't address it, because they're thinking this is addressed only one time they need to address it. Anything that happens within 5 days needs to be returned, any contributions, committees, non-committees, or whatever.
Well, hopefully somebody, not necessarily you
I don't think I
because
would
of your
want to do that,
position,
no.
but that somebody will carry this whole discussion back to the board.
Well, this
None
whole
of us
thing
are
is-
disagreeing with each
No.
other. We just simply have a different idea of how.
Right, I
how
agree.
to
And
do
this
it.
whole campaign finance, as you know,
Yeah.
that's why I didn't vote against one of their supervisors. They're going to rewrite the whole thing. So we're going to go into this whole situation. We just tried to finalize it so that people could go into their campaigns here within a month and do it. But the whole thing is going to come up in,
Yeah,
I think,
we don't want this to
September.
get into a game of gotcha.
No, and I think that's what's happened with the whole thing, and people use it, and that's the whole deal. I know that one of their supervisors was concerned about how people were using this campaign finance, and that's not what the intent was. We're looking for good
Unfortunately,
government.
politics is a game of
Politics is
gotcha.
You were gonna say
I would just wanted to address what I said about getting caught. I don't want to see the burden shifting to the Elections Department so that everything can go along and until the Elections Department catches a violation, and, oh, well, we'll be happy to return it within 5 days then. I think that obligation belongs to the campaigns.
No, I agree.
And to
And I think the
agree with
ordinance
that.
says
I
that.
totally agree. I'm not saying it's that. but now
So
people
that was
intend.
where I was
I
coming
appreciate
from
that.
with my comment.
Right.
If all of these contributions came to one committee, no matter how inexperienced your treasurer was, your treasurer or someone's treasurer should have been experienced enough to say, oops, these all came, instead of waiting until the Elections Department discovered it on its own.
Right. No,
That's
and-
my-
yeah,
that was
no,
where I
and-
was
and
coming from.
I figured that's where you were coming from, but your words were a little different than that.
Well, they were briefer, so now, and hopefully now I've,
Clearly, no, but I appreciate that, but there was no intent.
You're asking us, just to be sure, the recommendation from the plaintiff in this hearing is no fine.
Well, I'm looking, no fine and no violation.
That's
Because
what I was
that-
going to say,
yeah,
but
that- I mean, this is
you're
it.
asking us that we find there is no violation.
There's no violation at all, exactly. That's what the intent of the supervisors when they voted on this, or to clarify that there was no violation. I'm sitting back and just making a comment over all the issues that you've had to deal with a couple of their supervisors saying that there's no violation. Three of them said there's no violation there. And that's why they came back and did this. Like I said, I didn't know it was coming up. They just brought it in. It was, again, I wouldn't have brought it up myself because of the situation we're in, of course. But, yeah, that was their intent.
Well, I've read the paperwork. I'm not sure. It may be what their intent is. I'm not sure it's what they said. And I certainly would have much preferred to have seen it rather than in a memo of this is what we intended with these words, to have seen them amend the words themselves to make it clear. And I still hope they'll do that.
Okay, that's good.
Because I would agree, at some point, there should be a de minimis. All right?
Okay, thank you.
Okay. Any other questions?
No.
None, okay. Thank you very much. All right. Is that the end of the hearing? Are there anybody else other than Mr. Williams I know that would be heard?
I believe the only other thing is that the rules give the opportunity for the petitioner to have a rebuttal to conclude the presentations, and then it's your time to deliberate.
All right. Mr. Hardy. Okay. Thank you. Okay. Comments?
Well, my initial concern is the interpretation of what the board says. If we are to broadly interpret what the board says, there is no violation. If we're to rely on the existence of the ordinance as it stands presently, there is. And that's a very difficult dilemma upon which to render a decision.
As they say, that's why they pay you the big money. I'm sorry.
Yes.
Any other? What is it then you feel we should do? One, find a violation, or not?
Well, that's my problem, and that's what I'm hoping to elicit some discussion from my learned colleagues on this, and to sense where you are coming from, because I think this is a good opportunity to do that.
In my opinion, the memo that we received is no better written than the ordinance itself. And so in terms of 1267A,
Now it's going to get, now Mr. Williams is going to take it back to the board saying we criticized the board.
well, we're being recorded. I'm getting used to that.
But without that, basically, do you feel the ordinance finds there is or is not a violation?
I believe the ordinance finds there is a violation.
Okay.
I believe it's vague about whether or not it. I suppose that they intended that there should be no penalty if it's discovered within 5 days.
But it wasn't, was it? Was it discovered within 5 days?
No, I think the facts are that it was discovered and stipulated to the facts where it was discovered and returned within 5 days.
Within 5 days.
Okay, it was.
It was discovered by the elections department, and the committee was made aware of it. Isn't that correct?
Well, whoever discovered it, would that matter?
No, it doesn't, because that's what the provision says.
Right.
Upon notice of the violation. So it was returned, but I didn't mean to interrupt
That's
you.
Okay. Ms. Tolmack.
Yeah, was rereading the board's statements, and as to whether there's a violation, it just seems to me that they're saying that there really is not a violation.
They're saying that was their intent, yes, I think.
And we're and the rules are adopted by the Board of Supervisors, and it's their ordinance, it's not ours. So I think that's what they are saying, is that it wouldn't be a violation if it's returned within 5 days.
So you're not concerned about the difference between one committee versus multiple committees, as Mr. Wutcher pointed out? 1267A versus 1269C?
Yeah. No, because that they haven't interpreted that.
No,
the board has not interpreted.
They didn't.
1267, and so
And that's,
And if they do, we don't know what they're would say about it.
the 1267 is the section of the ordinance that we're dealing with here, not 1269.
Because it's, let's see,
Because it was one committee rather than multiple committees.
right, yeah, right, yeah.
Well, I think also if you look at, as you were pointing out, exactly what the board does say as identified on 9B, they only speak of 1269 here.
Yeah.
They're
Right,
only
1269C.
referencing 1269 in terms of the 5-day grace period, which is unfortunate because if they intended it to apply to 1267, they could have very easily included that in their guidance or their interpretation or intent.
Well, it would be my intent right now, just as a matter of procedure, to ask for a vote, I think, on two different issues. First one is the whether or not there was a violation. And secondly, if there was a violation, what the penalty should be. I just say that so that all of you can be thinking about that.
And it might, for the record, be even more to clarify that, a violation of what specific provision of the ordinance
All right.
would you find having been violated? Because that may have some significance as well. And as we point out, these are appealable, so it is something that we want to make a clean record as to what the
I don't think I'll
exactly
hear the
finding
writ of
was.
mandate, though. All right. Does everybody understand how it's going to be phrased? And is everyone prepared to make a decision, individual decision on that?
Yes.
In an interest of speed, let me start at this end. Ms. Jones, on the issue of whether there was a violation and what under what ordinance section?
I would find that there was a violation under 1267A.
Okay.
I find there's a violation under 1267A with a legitimate concern regarding the interpretation from the Board of Supervisors.
Oh, what's that last?
I'm legitimately concerned regarding the interpretation as sent to us by the Board of Supervisors.
Okay. Ms. Tomac.
I guess since the information that we received from the Board of Supervisors relates to 1269, I think their interpretation of their intent in enacting 1269, that there was no violation here, and that.
How do you feel?
And I would support their position on that.
Okay.
And I'm not
So you're-
raising the issue of the 1267.
So you're saying there is no violation under either code section?
Well, under 1269 is what I'm.
Under 1269? What about 1267?
Well, I just since the writers of the ordinance are viewing this as strictly under 1269C, that I'm because they wrote the ordinance, I'm leaving that in their interpretation of this action as it relates to 1269 in their interpretation. And I think that we'll be messing around with this ordinance for quite a while. And so I really haven't studied 1267 carefully enough.
We can get a copy of it, and Mr. Wiltshire will.
I got it. I have it right here.
Oh, you have it here? All right.
I got mine here.
So you're finding that there was no violation under 1269?
See, yeah.
Okay, and no decision on 1267, is that correct?
Uh-huh.
All right.
For non-participating candidates, let's say.
Okay. Looking at this, speaking now for myself, I think I understand what it is the board was attempting to do. I have the problem I have is that I don't know that the ordinance is that ambiguous or that unintelligible. It seems to me that whether it ought to have been, or even whether or not they meant it to be, to me it says that there is a violation under 1267, and I certainly would implore them to amend it, or to work with us to amend it to make it clearer, because I think we need to be uniform in our rulings, which means that we need to be absolutely clear in the ordinance that we're operating under. But my vote is yes on the violation under 1267, and that being, I think, now a majority 3-1. We get to the second issue, and the second issue was what, if any, penalty should we assess for that?
You want to take a motion first, just to put this violation?
Yeah, all right. I was just taking from my notes. Let me make a motion on whether there's a violation or it's under 1267.
I will so move.
Okay. Okay. Anyone was to be heard? All in favor?
Aye.
Aye. Opposed?
I won't oppose it.
You what?
I won't oppose it.
You just did, I thought.
Well, yeah, but I meant, I was refraining from addressing 1267. That's what I was doing, and so
Okay.
I'm not, okay, so
You're abstaining.
Abstain from that, okay.
All right. Is that sufficient? Okay.
Got 3.
All right, then the next issue is the penalty, if any. Again, let me ask Ms. Jones, Ms. Renier.
Well, I think I would be inclined to go along with Mr. Hardy, that because he did the investigation and he made the determination as to maliciousness or lack thereof, that there should be no penalty in this situation.
I agree. No penalty.
And I also agree.
Okay. We have a unanimous opinion, I think, on that. It's difficult because you might even say it's a technical violation, but it is.
Yeah.
But I agree that Mr. Hardy, that I'm not in favor of any penalty for 2 reasons. One, because I think it's turned out at least to be more a technical violation. 1, and 2, it's not what, in my opinion, it's clearly not what the board intended. But that is what we've got now. So we need a motion on no penalty.
So moved.
Second. All in favor?
Aye.
Aye. Opposed? Okay.
Yeah, and if I may just add on that, it's, I think, a very strong argument for no penalty is that it's taken us, close to an hour to determine exactly how we feel about this particular ordinance. I mean, it's very difficult, and therefore a violation of an ordinance where there could be multiple interpretations is one that I think we have to change, because in the event that there is perhaps a more serious violation, we could again be confronted with this same issue.
And I would prefer to have it addressed by the board formally rather than a memo. This is what we really meant. That puts us in an awkward position.
Exactly.
No. Well, once again, let me ask, is this something that the board would write, or is this something that it's basically our job to write?
Well, just if you're looking for an answer from, I mean, if somebody's going to write an amendment, I believe you always can agenda an item to propose amendments to the ordinance that have come to your attention that are in need of amendment through the activities that occur to you.
Well, if it is, I would certainly like to do it. I think we can shortcut a long ways, because I don't think that we are out of step with the Board of Supervisors in terms of what we would like to do.
But, well, and I just want to separate that in terms of what the ordinance means. I think if you think there's some lack of clarity as to whether or not, how to interpret the ordinance, that is something that probably would best be affected by actually amending the ordinance to make it clear, let the board have the opportunity to make clear what they mean in a way that it's
okay. Well, if
you
that's
can
the
deal with
case,
it.
clearly that is how we feel.
If it's respect to the penalties, I do believe almost all of these types of ordinances are going to have a range of penalties, or be expressed in a similar fashion, which is there to allow the administrative body to tailor the penalty to the facts of a particular case.
Well, what I'm thinking specifically is that, one, I think we've already instructed for the staff to bring back to us a schedule of penalties, which will give us the uniformity and perhaps to be able to set into writing how we feel. But what I was thinking right now was, if the board thinks there should be a de minimis level on whether or not there's any penalty at all, that I think needs to be clarified.
But I think that's something that the board should do. I don't
Well,
think
that's what I
that should
hear.
be coming from us, that
That's
we
what I-
request they do that.
I think that's what Mr. Wilshire was saying.
Yeah, I mean, if they want if they want their ordinance to be clear, then the impetus is upon them to make it clear. Because I didn't need an hour to determine that there was a violation of 1267. It seemed clear to me.
Why did they discuss 1269 instead of 1267?
That's my problem with getting a little memo like that, that's not clear either. That's why I said that was as poorly written as apparently 1269 itself.
Do we need to instruct anybody to take this back to the board?
Well, I think there's two options. One, the board may have heard or may come to hear what just transpired, and they may take it upon themselves on their own initiative. Or, since I do think if you want to do anything more formally, it probably ought to be done as an agenda item. It ought to be instruct staff to place it on the next agenda to actually adopt a motion or something like that to request the board to take some action. But otherwise, I think
We need to put it over until the next time.
well, it's not been agendas as a policy issue. It's in the context of this administrative hearing, and obviously your comments that you make in the context of that hearing are recorded, can be heard, things like that. But if you really wanted to put any force of commission action behind it, or to have any more broader policy discussion about that issue than you've just had, I think it probably needs to be done as another agenda item where the public would have the opportunity to speak to it.
To us or to the board?
To whether you want to ask the board to do anything.
Yeah. Like I said earlier, I'm very concerned about a line of demarcation between the commission and the board. I mean, while our job isn't to interpret their ordinance, getting memos saying this is what we meant just kind of doesn't pass the smell test for me. And so they need to take that upon themselves. And that's just my opinion. If they want to make something clearer, knock themselves out. But I don't think that it needs to come from us at this point.
If I can just clarify one point, the memo that was attached to your agenda was 9B, was from staff. The way it happened is that there were revisions made to the ordinance. There was a second reading at Tuesday's board meeting. As part of the adoption of the revisions to the ordinance at that second reading, Supervisor Bennett included in his motion a statement of intent, which is now part of the official board action that was adopting the revisions to the ordinance. And what staff did was just attach a written version of his statement of intent for your information. So there was no direction from the board that be given to you. It was not a writing that was submitted to staff and with directions to provide it to the commission. That was just staff advising you as to what happened at the board meeting and giving you a written version of what was stated orally and became part of the official record.
Thank you for that clarification.
Do you want to take any further action?
Well, based on that information, then I think we should, or my recommendation would be that we have it included as an agenda item. And the specific concern I have is the language of 1267. And if it's the board's intent to incorporate a provision similar to 1269C in 1267, then I would ask that that be put on as a agenda item for our next meeting.
Second.
Okay. Second? All in favor?
Aye.
Aye.
I'm opposed.
You're opposed. Okay. 3-1. Are we finished with this item now? Anything further? We still have one item left, item 11. Another can of worms. Mr. Hardy. Thank you.
Okay, Honorable Chair, members of the Commission, before you I have a request to amend a complaint in case number 2006-15. As you can see in the request, I ask you to look at the substance in the request, to consider that, to find that probable cause exists for possible violations set forth therein, and then to direct the clerk to amend the complaint to include those possible violations. I can go over each potential violation if you wish. I do note that this is just a very preliminary stage. We're not talking about an evidentiary hearing or anything else akin to that. I'm just asking for a probable cause determination so the complaint can be amended.
Doesn't probable cause generally come to us with a recommendation? Whenever we get a complaint, we usually ship it out and ask for a recommendation.
Let me refer you to the provision of the policy that I'm operating under. if you have the operating procedures before you, this is Article 3.
I have no idea right now whether or not there is probable cause or is not.
Well, let me let me explain procedurally
Sure.
what's going on here. Under Article 3, Section 8, subsection C, and I can just read this for you if you don't have that in front of you.
I don't have the
It says,
ordinance in
"The
front of me.
commission may also consider potential violations of this ordinance without receiving a complaint. In this situation, if the commission determines that probable cause exists to believe that a violation of the ordinance has occurred, then the commission shall instruct the clerk of the commission to prepare and file a complaint setting forth the allegations."
Would your recommendations be included in?
Yes, Your Honor. Yes.
So this is what we should be looking at.
Absolutely.
All right.
You're recommending that probable cause be found, correct?
I recommend that probable cause be found on those 3 items that I set forth. To give you a picture of what's going on here, I have reviewed records that have been made available to me subsequent to the original complaint, and I found things that could very well be violations, and they are violations on their face. Part of the reason, to be frank, part of the reason why I have to do this is because there's been somewhat of an objection to my inquiry on the items that I've listed in as additional potential violations on the grounds that they were not part of the original complaint. I did make certain inquiries to counsel to respondent, and there was some response, but part of the response was that I'm asking about things that were not in the original complaint. My position is I see evidence on its face that suggests a possible violation, unless there is an amendment to a filing. But short of an amendment to a filing, I've seen certain information on its face that very well could be a complaint. I feel obligated to pursue that, at least at some minimal level, but I have not been able to do that because it hasn't been part of the original complaint.
Are you being stonewalled?
Well, I wouldn't use those strong words, but there's...
In Washington, that happens all the time.
Well, and I'm not taking a position whether that's a good response or not by respondent's counsel. Maybe, if he wants everything in...
It seems a sophism to say, well, it's not in the original complaint, and therefore, even though you caught me with a smoking gun, it's okay.
Well, I guess I don't need to make a comment on that. I just know I would like to make the complaint, include those matters, and then proceed and see if there really is a violation or not. I just know that the information that is available to me to date is problematic unless it's amended. I do add that some of the information I've reviewed is partial information. And Respondent's Counsel has admitted that in response to my request to amend the complaint, they have stated that they will do supplementary filings. So it may all wash out in the end, but at this point, I would like my request is...
Are documents in order to further your investigation being withheld? Is that... I'm trying to translate what you're saying.
There's information that I would like to... some of the filings have been partial. The forms haven't been completely filled out. That's the issue.
So in some of these, we may find probable cause. You will nothing further will come up.
It's possible that I'll dismiss the complaint or that charge of the complaint if the supplementary filing is such that it answers my questions. It may not necessarily be the case if I have a question about it and I need further documentation, but it's certainly possible that supplementary filings will result in those charges being dismissed. It's hard for me to say at this point because I have a lack of information.
I think that's all I need to know.
Well, I just want to make sure that there is probable cause.
That is why I have attached certain documents to my request.
So you look at these.
To support my position.
Your Honor, may I?
Yes.
A couple of things. With the probable cause, you might be getting a little ahead of yourselves at this point. Generally, the way the procedures have worked is a complaint is filed, then there is a determination whether there's probable cause for it to go forward. So in this context, I'm not sure that you would need to do that analysis at this point. The other issue is that in the revisions to the ordinance that were just adopted and which become effective June 8th, the board specifically has now provided in the ordinance that outside counsel, Mr. Hardy and Mr. Steele, who are currently retained, and others that maybe in the future, are to be retained to do that initial review of the complaint. So under the revised ordinance, effective June 8th, your commission will no longer be conducting that probable cause determination. A complaint will come in, and the operating procedures will have to be revised accordingly, and that is in the works. When a complaint is filed, it will just be assigned to a investigating attorney to review and move forward with the process and bring it to the commission.
Far prefer that. I had concerns about that a year and a half ago when we started out, that I don't mind being prosecutor, defense, or judge, but I feel very uncomfortable being all three.
Exactly, and that I think was a large part for that particular change. But I think now at today's stage, the issue is really whether you want to authorize an amendment to the complaint, allowing that a probable cause determination or whatever would then follow according to the procedures. I believe that this is a brand new process. We've never undergone this particular request for an amendment before, but I believe that under the ordinance and the procedures as they exist, that there's a mechanism for that, because the commission is authorized to consider potential violations of the ordinance without receiving a complaint, which this somewhat falls into. The clerk is authorized to bring complaints forward, the clerk of the commission, under 1295I and 1296 subsection D of the ordinance. So I think the procedure here would be that if you find there is good, not probable cause, but that you find that it's should be allowed to amend the ordinance to at least allege these claims, that you would instruct the clerk to prepare that with Mr. Hardy. Would not be Mr. Hardy. It would just be an amended complaint that would then be filed with your commission.
Given that, what would be the argument against?
Not much. I liken this very much to a civil court proceeding where a plaintiff wants to amend a complaint. The policy is that is liberally allowed, the amendment. If there are problems with the amendment, they can then be challenged through a demurrer in civil court, here a dismissal motion, so that these are just allegations at this point to bring them within the scope of what's being investigated, and then if they're either factually deficient or legally deficient, they can be challenged, but not until they're actually part of the complaint.
Well, in civil court, a First Amendment is a matter of right. So you don't even need leave of court to do that. So.
Right. We don't have that, but at least with the general policy, I mean, this issue isn't really addressed at all in our directly as far as amendments, but there certainly is a general policy of allowing claims to be asserted and then fleshed out and heard on their merits.
Well, I would move that we...
Well, we haven't got there yet. We've got
okay. I'm trying to move things along here. Sorry.
Yeah. Go ahead, Mr. Hardy.
Well, what would the commission be comfortable with at this point?
Well, I have a couple of requests to be heard, one from Mr. Williams and one from Mr. Osborne.
Okay.
So I would want to do that before we take any action.
Oh, okay. I wasn't aware we had.
Yeah.
And if I may have a response after that, if necessary.
Yes, you
Thank
may.
you.
Could Mr. Osborne go first? Oh, I would prefer to go last. I don't want to hear what he's doing.
Okay, well,
Mr. Williams.
huh? Yeah. I was about to ask, does anybody care who goes first? But
I didn't want to muddy the waters. Good afternoon. I'm the respondent. I'm Mike Osborne. I'm the chairman of the Ventura County Republican Central Committee. I don't know that you've had time to read the letter from our council. The issue here today, and what we want to make sure.
Yeah, Mr. Bell's letter is in our
Yes,
packet.
it is in the file. Our issue today is we deal with what the commission has purview over. And I think what Mr. Hardy mistook Mr. Bell saying is that not to the original complaint, but to the fact of what the commission actually has authority to deal with, which is violations of the county campaign ordinance. The commission has no ability to deal with the reporting provision of the Political Reform Act. And the issues we're talking about are missing check marks, a problem with the numbering system, various things that are mechanical violations that are under the purview of the FPPC, and if someone would like to make a complaint to them, they deal with these things as a request for an amendment to the filing. The real issue we have to that we have to deal with here is whether there's been a violation of the county ordinance. And to that end, it has been our contention that everything that is under question here has been what is described as a member communication in state law. That is uncontroverted. It has not been argued, or there's not been a claim or an allegation that these weren't member communications. Even Mr. Hardy at our meeting has agreed that no one has made a contention what we did were not member communications. Now, the other issue at hand is state law, and state law specifically says that member communications that local ordinances do not apply to member communications. That is a fact. That is statute. And in fact, the statute, the FPPC rulings, and everything were supplied to the clerk. And one of the reasons we're here today is because the process is flawed, and that is why the Board of Supervisors has chosen to attempt to repair it. The issues, regardless of the amendments we have to make, which we have agreed to do, everything that we have done is available. It has been made available to Mr. Hardy. There's nothing that's been refused him.
I think Mr. Hardy has already indicated that
there is a missing check mark on one filing. There's a question of two different forms, although both forms are approved by the state to use. And to make it clear as you go through all this, the state of California has not developed a form to deal with member communications. So they request that you use either independent expenditure or in-kind contribution form. Either one is acceptable to the state. And a perfect example of what's happened in some of this is that the state's print engine that generates reports from the electronic filings has a corrupt code, and it doesn't properly number the pages. And on the state,
corrupt code?
It has a bad code, and it does not correctly number the pages when you print out a document from the electronic filing. And there's even a part on the compliance of the state website that tells you this and says the state is more than happy to accept these pages without consecutive numbers. Yet the county has sent us a request for an amendment because the numbers aren't proper. We went ahead and numbered them and sent it back, as an amendment. But these deficiencies that Mr. Hardy's talking about are things that are taken care of with amended filings with the state all the time. It's absolutely standard procedure and is not treated as a violation of any kind, and in fact is not even enforceable by the county. It is enforceable by the FPPC.
But the question before us is not a determination of whether you're right or wrong, or whether or not we have jurisdiction or not, but a determination, an initial determination started with a complaint.
Oh, absolutely.
At which point there'll be an investigation, and very well may totally absolve you. That's my question.
No question of that. We're just objecting to the amendment because it takes us far afield of what the actual question is. It takes us away from the question of whether or not state law trumps the county ordinance. That's the question here, and that's the only question.
But this isn't the time to determine.
I understand that. But what we are objecting to is amending the complaint for issues that A, you have no jurisdiction over, and B, would just muddy the waters on the original question. And that is our objection.
Okay. Thank you.
Thank you.
Mr. Williams?
Thank you, Your Honor. Carol Dean Williams, I've heard talk of uniformity, and Mr. Smith repeated what I heard the board say Tuesday. He's already said it, so I don't need to say it. The one question is why they didn't send you a memo on that, which, as the court knows, it seemed like this is moot. Your favorite court saying, what's the purpose of this now?
that this new revision goes in effect in a month after they adopted it.
What's your point? Where are you going with this? I'm not sure.
Well, did you understand what Mr. Smith said? Did you understand what Mr. Smith said? I don't think you understood what he said. The board said you people shouldn't be involved in this anymore, and they just revised the ordinance. You've mentioned probable cause, you mentioned all this stuff, but I want to get to the point of why I'm talking, but he already talked to that. Everybody goes blank now. Well, do you have the request for the amended complaint in front of you? Let me read this. This ordinance in connection with non-monetary contributions, and it gives the amount. I filed an exact complaint against Linda Park for the Ventura County Star for non-monetary contributions, which the election says the Star had to file as a contribution. They didn't do it. This commission found no fault.
We're over the 5 minutes now. That at least is one thing I do understand.
Okay, so I'd just like to remind you of your uniformity statement. You're not being uniform.
Okay.
If you need clarification, I'll be happy to clarify.
We haven't got time. Thank you.
Thank you.
Okay, anybody else on this? You wanted time for rebuttal?
No, thank you, Your Honor.
Okay.
Why do you always look at me?
Well, because I don't want to dominate the thing, but I end up doing it anyway. I can't for the life of me think of any logical reason to deny this request.
No, I don't either.
I can't either.
No, I mean, it's just an amendment to a complaint. It may turn out to be nothing. I mean, we did run in a year and a half ago to a situation where we found no probable cause because our ordinance did not address an issue that the state ordinance did. And so I'm familiar with that argument. But I don't know anything about this yet until there's an amended complaint and a probable cause determination. So I don't see the harm in allowing an amended complaint.
Ms. Tolman?
I'd agree with that.
Okay. You can't hide.
Right.
All right. You agree with
I
that?
agree.
All right. Then we need a motion.
Also move.
Second.
Moved and seconded to allow the amendments to be filed.
If I may just
Yes.
be a little more, add a little clarity to your motion. The motion should probably, I believe, direct the clerk of the commission to prepare and file an amended complaint with the under the direction and information provided by Mr. Hardy, because it would be the clerk that would be filing this amended complaint, not Mr. Hardy, and that would be then filed by the clerk with the clerk on behalf of your commission.
That is so articulate that I adopt that language as my own in my motion.
Okay. And seconded.
Yes.
Any further discussion? All in favor, say aye.
Aye.
Aye. Opposed? Clerk is so ordered. Okay. I think the last item on the agenda is scheduling our next meeting, which is proposed to be Friday, June the 8th at 12:30.
That's correct.
Anybody have any problems with that?
That was a date that the commission members had indicated earlier looked like a good day for you. If things have changed and that's not a good date, we can always adjust it for another time.
Okay. We don't need a motion on that. The 8th of June, 12:30, in the boardroom here. Anything else to come before the committee? If not, thank you very, very much, and we will be adjourned.